So good evening, everyone. Welcome to the Medventions lecture series. I'm very pleased to be introducing our speaker today, Dr. Gabriella Chan, who is actually wearing many hats. She's a scientist, a lawyer, an entrepreneur, and a lecturer as well. She'll be discussing one of the most, I would say, challenging but essential topics. And no matter how, I was just telling her, no matter how experienced you are in med tech, IP is always a very challenging topic. I would like just to make some very quick housekeeping announcements before we get into today's specifics. Our next workshop is scheduled again as Thursday, October 12th, where we're having Dr. Jason Parker, who will be giving us a workshop on the regulatory environment. The other following one is a workshop on October 19th. We're having Dr. Joseph Fehrenbach from U of T, and who will be discussing the typical ideation and brainstorming methods that are typically utilized when coming up with novel concepts in medtech. Again, the structure of these workshops, we always start by a lecture component, which will be available via webcast for online viewing. And then usually we get a small break, and then there is a hands-on exercise, which is only available for attendees here at Sunnybrook. Please know that the Medventions annual Innovation Day has been rescheduled. It was planned to take place on December 12th of this year. Now it has been rescheduled to Thursday, February 8th in 2018. So yeah, please mark your calendars. We're expecting very good speakers. This will be, more details will be announced soon in the next few weeks. So back to our workshop today. Again, we will start by 90 to 120 minutes lecture time, where Gabriella will walk us through the origins and policy behind patent systems and filing and freedom to operate analysis. We'll then take a very short break, like 15 minutes break, and then we will have a hands-on kind of exercise where Gabriella will provide a guided exploration of a real-world issued patent for a very prominent medical device, Toronto medical device company. A little bit of background for Gabriella. So as I mentioned earlier, Gabriella is a scientist, a lawyer, a lecturer, and an entrepreneur. She completed a PhD in molecular diagnostics for infectious diseases and undertook postdoctoral work in handheld diagnostics, diagnostic devices at U of T. She then earned a law degree, a JD from Osgoode Hall Law School, with a focus in business law and intellectual property, and trained at a national Bay Street law firm in Toronto. Before founding Yocto Law, her company, Gabriella served as a VP of Legal Affairs at a Toronto area biotechnology company. Gabriella now advises researchers, startups, ventures, established companies, and stakeholders in the life sciences and health technology sectors. In addition to her legal practice, Gabriella is also an adjunct professor in the Department of Laboratory Medicine and Pathobiology, and a course director in the Translational Research Program at the University of Toronto, where she teaches intellectual property and commercialization. Lastly, Gabriella is a mentor at the Health Innovation Hub and the former lead of Startup Toronto. Gabriella, thank you very much for delivering today's workshop.
Hello, everybody. Thank you, Dr. Nassif, for inviting me to present some of the driest areas of law there is for some. I've sat through a number of these dry topics myself, so I feel your pain, and I tried to make this as interactive as possible. So hopefully by the end of it all, you'll walk away knowing at least a few things about what to do, and most importantly, what not to do when it comes to IP. So we're talking about patents generally. Anybody in the room does anybody have direct experience with patents? Okay. How was it? Tough. That's usually how it goes. So I'll make it so that, or try to make it so that it's more enjoyable and less tough, and next time around it won't be so bad. So as Guy Kawasaki says, ideas are easy, but implementation is hard. He referred to this in the context of a business, and starting a business, and in tech, because he's a tech guy, but it applies just as well to IP, because it's not easy to go through. So just as a framework, of where IP fits, and we look at entrepreneurship, and all of these covers of entrepreneur have very happy people representing the wealth you can have as an entrepreneur. And I don't know where they're going, especially this woman throwing that looks like fairy dust into the wind. Sometimes that's your life and your ideas in your company. Actually, 90% of the time, within 5 years of something starting up, it ends up in smoke or dust. So the context is everybody and their brother wants to be an entrepreneur. It's not as easy as it sounds, and for a variety of reasons, companies fail. For a lot of reasons, and one of them is really creating a business or a product for a non-existent need. But that's another topic and a whole lecture altogether. So the interest is you have an invention, and then you actually want to make money from it. So what comes in the middle? Well, it's the commercialization. Dr. Fehrenbach at the TRP would argue, and I have an extra slide usually for this, for the translation piece, because you need to translate it before you commercialize it. And it doesn't mean science to English, it just means the translation of bench to bedside applications of inventions. So when you talk about commercialization, there's a lot of stuff you actually need to worry about. And only a small piece of it is actually generating the IP, protecting the IP, branding it, creating your patent strategy, freedom to operate, all these lovely things that we're going to discuss today. And it won't sound so strange once you've sat through this, hopefully not painful presentation. So IP, what is it? It's intellectual. What exactly does that mean? This is an interactive class, so what does intellectual mean? Part of your brain. See, easy. And it's property. Now, what does property really mean? This is not necessarily the most straightforward of things, because people think of property as it being a thing. You all have your phones, that's your property, and it's a thing, but it's not really quite that. It's a bundle of rights that are given to you, and there is a ranking in the bundle of rights, and this is property law 101, so we're not going to go down that road, but suffice it to say that it's just, think of it as a right, tangible and intangible, that you can buy, sell, lease, and do anything with, but it's not an actual thing. So to really dive into that just a little bit more, so you have a contextual understanding of where IP fits, you have your usual real property, your houses, condos, so farms, whatever, land, personal property, and then other, which is public property, and aboriginal interests actually fall in the other category. Then personal property splits again into leases, so they're called chattels real. Don't mind the language, it's very arcane. And then chattels personal, that's the personal piece. And that splits into choses in possession and choses in action. I told you this is archaic. So one is tangible and the other one's intangible. So where IP fits is at the bottom over there. Choses in action that are intangibles, and it's in the same boat as shares, if you own shares of any companies, or debt instruments, or IP. So with that in mind, what are the types of intellectual property? One is in the title. Patents. All right. What else? Trademarks, copyright. That's usually where it stops. Pardon?
Trade secrets.
Not technically IP. It's more confidential information, but it's on the list. More? There's two more. So patents. What's industrial design? This is what the Americans call design patents. So it refers to the highlights of industrial design battles or design patent battles is Apple versus Samsung. And most of their IP battles are based on design, the look and feel. How do you actually, what does it look like? And is it too close to what it looks like? Now everybody has that screen that goes edge to edge and the rounded screen. There's a lot of battles over that. So industrial design, trademarks we covered, copyright we covered, plant breeders' rights. there's a huge thing, you know, Monsanto Canada, we'll talk about them shortly. There's a thing where it protects plant breeders' rights. And integrated circuit topography. Any engineers in the room? So all of those circuit designs are protected under this. And then trade secrets, which is confidential information. There's a Trade Secrets Act in the US. We don't have one, it's not robust. But we'll talk about that because those are coming to the fore more and more given what's going on with some of the case law that we're going to discuss. So just a brief intro on policy for IP. Why is it important to protect intellectual property? Let's just stick to patents to make it simpler. Why would it matter? Why do you care for there to be an IP regime in the world? What does it do?
Competition.
Competition, okay. What else? Copying.
It allows you to sort of sell an idea.
You can monetize it, yeah. What else?
It allows innovation to be rewarded.
Yes. Okay, so that's a few. These are generally the summary points on what it does. It's supposed to fuel progress, because why would you invent, especially in a pharmaceutical that takes billions of dollars to get to market? Why would you want to do that when everything is in the public domain and everybody can turn around and compete with you and just take your idea? Once you got from A to B, which was the hardest part, somebody comes at B and just turns it around quicker than you can, and then you have no rights over it. So the idea is to protect these things. And that goes hand in hand with the incentive for R&D and the reward for intellectual effort, as somebody mentioned, and then the sharing of knowledge. Because remember, with a patent, it's in the public domain, it gets disclosed, and we'll talk about that. Versus a trade secret, that by definition is a secret, and it doesn't get disclosed. So trade secrets don't function in the same way in terms of sharing of knowledge by design. Now, what can you say against having patents and a patent system and protection of IP? People get very fired up about the cons.
Lawsuits.
Well, you can have lawsuits with and without. We're not as bad as the Americans, but still, they come around.
They could inspire alternative innovations.
Inspire alternative innovations, okay. One more try.
It slows the progress.
Slows progress? Is that what you're saying? It can. So most of the arguments is that it stifles competition, because people with deep pockets have the ability to go pay, you know, a lawyer or a patent agent at $800 an hour to patent something, where the regular rest of us just don't have that kind of luxury. So it impacts the societal split, the rich and the poor, the haves and the have-nots. So no matter what you have as a good idea, because you don't have the means to get it done, it's not going to happen, and therefore it creates inequality in society. So, and exploitation. So most people are very, very vocal about this part, the cons against IP. But that's a lot to go through as a discussion. So just to wrap this up then, so IP rights, they're meant to be a set of legal instruments by which you exercise this right to protect IP. And it's supposed to be a contract between the state, which is the public represents all of us, and the creator of the intellectual property. And the IP law itself is the device that's supposed to balance these rights between the owners and the users. So that's the overview of that. And lastly, why should you care? It's right there on the screen this time, but it's very, very important. It's a knowledge economy that we live in right now. It's not manufacturing anymore. And everything hinges on your IP and how well you can protect it and what you can do with it. So sadly, we're down this rabbit hole and we're not coming out the same way we came in. So that understanding where you sit with regards to IP and understanding this whole platform is really important, because without really having a baseline knowledge of what this entails, you can't make informed decisions about companies or anything else. And IP is extremely pervasive. Every contract, I'm sure each of you has signed a contract at some point, has IP in it. You know, you use any piece of software, there's copyright in it, and patents, and assigning your IP. If you work for an employer or the university or the hospitals, you assign IP. Well, what does that really mean? So hopefully by the end of it all, we'll know, or you'll know in a more applied way, how this impacts your life. Now, question. Can you practice an invention in Canada that is patented in the US without penalty?
Yes, as long as it's not patented in Canada and it passed the time where they could have been patented in Canada.
Exactly right. So IP is territorial, and patents in particular are also territorial. So if I have an invention that I have protected in the US, but I didn't bother to protect it in Canada, Dr. Nassif can go and practice it just fine in Canada. If you try to create the product based on the IP and ship it to the US, then you get into trouble. But as long as I don't have a patent protecting my IP in Canada, he's free to do whatever he wishes with it. The problem is most people go to the US to market everything. And so most people have IP in the US, but they don't necessarily think about doing the same protection or taking the same precautions and patenting in Canada. So a lot of times you can practice something in this jurisdiction that's a major problem in the US, so you wouldn't be able to do anything with it in the US, but you can do here because you're free and clear. So, just like I said, so the territoriality component is for every piece of IP that requires registration, trademark, copyright, and these go through certain conventions as it's listed there. So the Paris Convention allows you, if you patent in one jurisdiction, so say you patent in Canada, through the Paris Convention, you have a certain amount of time, 12 months, to go and say, well, US and Europe, whatever jurisdiction in Europe, I'd like a patent there too. And so then the Madrid Protocol does a similar thing for trademarks. So there are these patent and trademark conventions that allow you to leverage your IP protection from one jurisdiction to the other, but you do have to get it in each jurisdiction where you like to practice. All right, so true or false? Patents protect ideas. Bless you. 50-50 chance of getting it right. Who says yes? Who says no? Who's neutral? They don't. They don't protect ideas. What do you think they protect? Products of the mind. Like you really have to go through the process of putting it together. So patenting, so it says products of the mind. And it's a misconception because people think, oh, I have an idea, I'm going to get a patent on it. But actually you don't, because you actually have to show from beginning to end how you will actually implement this idea and invention. So you don't get patents on ideas purely as an idea. So patents and the patent systems go back way back when, into the 1400s and the 1600s, and they actually started because of the old guilds. Remember the wool guilds and the painters guilds and such things, and back in the day, that's what spurred the patent system. When those guilds, that system was dismantled, people started to think about how else we're going to be protecting the trade secrets that they had within those guilds, and so these patent systems began to develop. So in Canada and the US, the monopoly, so you get a monopoly for 20 years. And what that means comes another true and false. So which one of these is true? A patent gives the owner a right to practice, which means make, use, or sell the invention. It gives the inventor a right to practice the invention. It gives the inventor a right to exclude others from practicing the invention, or it gives the inventors the right to exclude others from practicing the invention. See? Oh, one should say owner. So let's pretend D says owner. So which one is it?
The one between C and D that was owner.
So right, it's the owner, right? The inventors are listed on the patent, and we'll see one live, but it's the owner that actually has the rights to exercise the patent. So just because you're an inventor doesn't give you any rights to do anything unless you're the inventor and the owner. So, and on that point, so patents are a negative right. Just because you have a patent on something does not by any means say that you can do whatever you want with your patent. It gives you the right to exclude others from doing what's in your patent. Makes sense? So it's a negative right, which means that, okay, never mind, there's a question about that, so I won't give you the answer. Can a patent infringe on another patent? Who says yes? Who says no? Who has no idea what I'm talking about? Okay, no, patents don't infringe patents. Products and services infringe other people's patents, but patents don't infringe other patents. I can have a patent that's just marginally different than Dr. Nassif's patent. It doesn't mean I can do anything with my patent because I would need to license my rights from him to use his piece of it. But I can get a patent on it. It's narrow, it's probably useless, but I can get a patent. That's why we have patents on methods of exercising a cat and methods for swinging on a swing and ridiculous things like that that clog the USPTO. We don't have quite as many of those, but the USPTO has troves. Okay, true or false? Only a product or service can infringe a patent. I just gave you that answer before. Just paying attention. Okay, an owner can receive a patent but cannot commercialize it. Yes? No? All right, and transitioning now, an inventor is synonymous with author. Is it the same thing? Yes, no? No, it's not, and that's a problem. Not for that particular reason, but because people, especially in academia, tend to think so. And that creates issues. So patents protect inventions. And then the question is, well, what's an invention? So Section 2 of the Patent Act tells you that it is any new useful art, process, machine, manufacture, composition of matter, and I won't read you the list, or any of the improvements on any of those. So it's A and basically A prime. Now, true and false. The USPTO and CIPO, that's the US Patent Office, and the Canadian Patent Office will not issue an improvement on a patent to an inventor other than to the inventor of the original invention.
That's false.
Why?
Sir?
Why?
Because just because someone else patents something doesn't mean that they have the rights to all future innovation.
Right, and that comes to that whole notion of accessibility, and you get a monopoly, so you can't get a monopoly for everything ever coming after that anybody else can decide that is an improvement on your patent. And then the second one, an inventor cannot practice an improvement on another invention. We covered this already, so it is true. Okay, so now part 2 of this, inventors. So patents are issued for inventions but granted to inventors. Who's an inventor and who decides? Surprisingly, there's no definition for inventor in the Patent Act. Shocking. So let's figure out who is and isn't. So an author, you're all in an academic institution. You've all gone through this with articles and presentations and papers with your PIs. Sometimes people end up on your paper that had nothing to do with your paper, but that's another issue. So you get credits to people who contributed to the successful completion of a project. Includes a whole number of people that may or may not need to be there, but are. And then Sometimes it's just used as a professional courtesy to add your collaborator who gave you, a stick of gum and said, here you go, and they end up on your paper. So there is a tendency in academia to treat inventorship in the same way. And it's actually not the case. So let's try this. A PI can be an author, but not an inventor. They would never think that, but it is true. A student can be an author, but not an inventor. Yes. A lab technician cannot be an inventor. False. And this is why. So an inventor, and who an inventor is determined by a legal factual analysis. So there's actually a legal exercise that you have to go through, and what that entails is actual creative involvement in the conception of the invention. And this is where it comes down to. The conception, these are defined terms, is the formation in the mind of the inventor of a definitive and permanent idea of the complete and operative invention, beginning to end, as it is to be applied in practice. So just because you're in a group and somebody says, oh, I have an idea, and my idea is X, and by the time you finish the group presentation and whatever it is that you're working on, idea X is actually XXXY, because that person only had a smidget of the idea. He or she may or may not be an inventor at the end of the day, because we'll talk about what it means ultimately. But it's not enough to say I have an idea, therefore I should get a patent, or I should get rights as an inventor on somebody else's development of the patent, full idea beginning to end, if that original person only had the general idea, but not the means by which the idea would be executed in practice. So you also have to demonstrate at least one claim, contribution to at least one claim of the issued patent. So patent has claims at the end, we'll talk about those, but the essence of a patent is its claims. That's the beginning, middle, and end of patenting. If it's not in the claims, it doesn't protect you. So say you had a group of 4 or 5 people working on an idea and developing a piece of IP. If each one of those people cannot point to a claim in a patent, they are not inventors. They might have contributed tangentially along the way. If there was a claim initially in some draft and it allowed them in, they could point to that and say that was my contribution. And through the prosecution process where the patent office and the owners negotiate what will and will not stay in this patent, that's a gray area. But ultimately, for an issued patent, every inventor should be able to point to at least one claim to which they contributed something. If they cannot do that, they're technically not an inventor. Now, the joy of multiple inventorships or multiple inventors is another issue, but just as I said, everybody needs to be able to point to something. So who is not an inventor? So as we talked about, if somebody just conceives the general idea of something, broad strokes, without really understanding how it would unfold beginning to end, not an inventor. If somebody just reduces something to practice, so you basically instruct somebody of what to do and how to make this thing that you invented, also not an inventor. They're called the inventor's hands, because you're literally instructing for them to use their hands to do what you have thought about. And also a person who contributes an extraneous idea during the development of an invention, but whose idea did not become part of the invention, which is we chatted about. If somebody gives you a reagent or materials to do something, this one's a bit trickier, because if they just simply hand you something, say it's an antibody, but they also, along with that, they give you the know-how of how you're going to use this so it fits into what you need for your invention, then there's an argument to be made that that person may be an inventor. So it's not straightforward, but if I need a pipette and I'm missing tips and I ask for some tips, that doesn't really qualify as a material that would qualify the other person as an inventor. So the supervisor of or a contributor to an experiment or a project, just because you supervise something does not make you an inventor. PIs usually push back on this because it's usually their lab, and they argue that, well, this is within my area of expertise. And therefore, no matter what the students or the postdocs in the lab may have come up with, were it not for me and my overarching scientific expertise in this domain, you wouldn't have gotten there in the first place. So therefore, I'm an inventor. So that creates a lot of problems, but people tend to sweep that under the rug because you want to graduate at some point. So that's a political matter. Now, how do you prove that you're an inventor? Does it matter that you're the Nobel Prize laureate of whatever it is field? Does that count for you to be an inventor or something? Should it? Because just because it's in a field of expertise doesn't mean you're an inventor on anything else. So you have to actually have evidence that you've created this thing, this invention, and you've conceived of it over some time. So what normally stands for evidence is testimony of non-inventors, people in the lab, people in your group, whoever you work with that have seen you do it. And the most important piece of it all is contemporaneous notes. So your lab notebooks, whatever you write these things in when you're inventing. If you're not an inventor in an academic institution and you come up with stuff, it's always good to have an idea notebook. You date things, you write them down in as much detail as you can, because that would support your position that it is you who actually invented this. And dates are critical. So you put dates down, you also number the pages so that nobody can come back and say, well, but you know, you just ripped that page out or you inserted something. And so the pages should be numbered. And the topping to this whole thing is to have an independent third party occasionally come and sign the pages to demonstrate that these things were done in sequence and there are no pages that have been ripped off or inserted that don't belong. So that would give you the evidence that you would need to do this. Now the problem comes in with electronic notebooks, and what the hell do you do with that? So when it comes to this, paper still rules and trumps electronics, because yes, forensically you can go and dig into this, but when you can hand somebody a physical notebook, it's a whole different matter. So, you know, if it's something sensitive, you shouldn't be putting it on anything, especially going into the cloud, because you might end up using it not as a patent, as a basis for a patent, but as the basis for a trade secret. And you don't want trade secrets floating around on the cloud. So the Coca-Cola recipe is a trade secret. Where do you think that the actual recipe is kept? Not in the cloud, we already covered that. It's in the vault in Coca-Cola land. Literally, there's a thing called Coca-Cola land, and there's a vault with the recipe in it. So keep that in mind. Now, what happens if you actually misidentify inventors? So this burns one way and slightly stings the other way. So if you were to have left somebody off a patent that should have been there, is that better or worse than including somebody who shouldn't have been there? Put yourself in that person's shoes. So you're left off a patent, or you are added to a patent, but in your heart of hearts, you know that you shouldn't be there. What's worse? What would tick you off more royally, one or the other? Which one? Not being on the patent. That causes a lot of problems. In the worst case scenario, it actually invalidates your patent. And that's well and good if you haven't done anything with the patent. But imagine if that patent was actually licensed to, say, big pharma or a big medtech company. They will be royally ticked off at you and sue you, because the person who wasn't on the patent and should have been will be put on the patent by the patent office, but that person never assigned their rights or licensed their rights under the IP to big pharma or big tech. So that person can now turn around and go do whatever the hell they want with that piece of IP because it's theirs and they're allowed to do that. So you get into a whole lot of hot water if you're not careful and you inadvertently, or not inadvertently, but purposefully leave somebody off a patent because out of spite, out of whatever. And there's been cases galore at the hospitals and the university where patents have gone nowhere because certain PIs, for example, didn't qualify as an inventor, and the tech transfer office said, you're not an inventor. And they said, no way in hell is this going forward without me on it. And it's not going anywhere because it's a huge risk. So keep that in mind, that just because you have a patent, especially when you try to monetize it and make licensing agreements with other people, it's really, really, really important that you don't go down this path. So co-inventions are always a joy. SRAs, sponsored research agreements. Do you guys know what those are? So in an academic setting or you work with industry and they say, you know, what is ours, what's yours is yours for this project. But if we work on something together, then it's joint IP. And we each have a piece of it. It's like splitting the baby. It doesn't really work. So the problem is that under law in the US, in the absence, this is actual language from the provisions. In the absence of any agreement to the contrary, each of the joint owners of a patent may make, use, offer to sell, or sell the patented invention within the United States, or import the patented invention into the United States without the consent and without accounting to the other owner. In Canada, it's similar. You can make, sell the patent invention in Canada without the consent of the co-owners, and you can assign the entire interest in a patent to a third party without the consent of the other co-owners and without accounting to them. And you cannot grant a valid license to a third party without the consent of the other owners. So say in the US case, the two of us are co-owners, co-inventors and co-owners of this. And we had a falling out. And I'm really ticked off. And I don't want you to do anything with that piece of IP. So I go and license it. I can't do that in the US, but I can in Canada, but I can in the US. License it to your arch enemy, just because I can. So how do you avoid this mess? That's a start. Other options? But see the first sentence, the first three words, in the absence of any agreement. So you come up with an agreement. Now, agreements are agreements, but there's an even better way. What's that? It involves a mutual entity. You set up a company and you both assign the IP to that company, then the company owns it, and the two of you can kill each other if you want to, but it's the company that owns it. And that's free and clear, and it bypasses all of the problems that joint ownership creates. Okay. So keep that in mind. So before we wrap up this section, practice tips. Inventorship is not a commodity. If the people you're working with don't really understand the difference between an author and an inventor, take it up with the tech transfer offices or whoever, go to a lawyer, have it figured out before you file things, because otherwise you're going to have a lot of trouble on your hands downstream. So it's better to sort these things out way up front. Okay. Questions on this before we move on? Good. So patentability. What do you need to patent? Pardon? Novelty. That kind of falls under the novelty piece.
Demonstration of functionality.
Yes. And?
It needs to be non-obvious and it needs to be useful.
New, useful, and non-obvious. That's usually how it goes. So new, what does that actually mean? Well, it's not anticipated by a thing called prior art. Any idea what prior art is? Prior art is basically everything in the world that the patent office can pull. So remember, patents are territorial, but prior art is international. So if it's written in Swahili and the patent office has access to it, and it goes counter to what you're claiming to be an invention, it's not novel or it's not new. So prior art, anything counts. If, for example, with academia, it gets tricky. So what about your thesis or any presentation you make in small group meeting? Would that count as prior, because it's a public disclosure? Is that public disclosure? Should you worry about these things? You should worry about these things. If you go, for example, to an international conference, let's just forget about the small group meeting, international conference, and you either present or you put a poster up, and everybody comes and starts tweeting off of your thing with pictures, and you haven't protected your IP before you left here, you're done, at least in some jurisdictions, as we'll talk about, because that is now part of the public domain. If the patent office can search it and find it, they will use your own invention against you as prior art, and you're done, because you cannot protect it anymore because it wasn't protected before it was disclosed. So that's one of the important pieces. Now, there's a thing called the grace period for 12 months from the first event of public disclosure to file a patent. This is the oops situation, where the US and Canada decided that they would like to spare inventors who inadvertently made this boo-boo. And now, rather than penalize them so stringently by not allowing them to patent it, they will let you have 12 months to fix your boo-boo. Now, usefulness, it must be operative, controllable, and reproducible on the basis of the specification. So you can't just spew whatever you want there and say, this is how it should work, but in actuality, it doesn't work. And non-obvious or inventive, this is the inventive piece. This one's interesting because it's who decides if it's inventive or not. So there's this thing called the person skilled in the art. And who this person is varies depending on context. So it's kind of tricky. And ultimately it comes down to this question of fact and degree. And obviously the grace period would apply to this non-obvious piece. But this is where you negotiate with the patent office back and forth about whether it is obvious or it isn't obvious. And that's where most of the crux of prosecution lies, because it's one of the main pillars of patentability. So we've already gone through this, so I'm not going to dwell on it. So grace period, just to recap, the US and Canada have a thing called absolute novelty. And it's 12 months from the time you disclose, event of public disclosure, you're protected. Then Europe and Asia has a thing called strict absolute novelty, where there is no grace period. So if you wanted to patent that invention in the US and worldwide, as far as your pockets will hold you to go, and you accidentally disclose, you're done for everywhere else other than the US and Canada. There are a couple of other jurisdictions that allow you 6 months, but don't count on that as a rule. Just make sure you protect things before you go present or put them out in the public domain. And if you really can't patent and you really don't want your competitor to put anything into the patent office protecting a certain piece of IP, you just publish it. But you publish it with enough substance for it to be enabling, this thing called enabling disclosure. It has to be enough for somebody to look at a slide or whatever it is you're presenting and actually be able to do the whole thing beginning to end. If it's just a snippet in the abstract, it doesn't really count, but that's something that has to be decided. And again, you want to avoid any of that. But if you really, really, really don't like somebody and what the IP may be coming out of that entity or person, you can just publish preemptively, and that becomes prior art against the other side. But the timing of that is important. And again, it has to be sufficiently enabling. So these are the drier ends of requirements for patentability. The key one that's gotten a lot of attention in the Supreme Court lately, not so much here, but in the US, is patentable subject matter. So Is everything under the sun patentable? And should everything under the sun be patentable? Can you patent anything? I told you methods of exercising a cat. Pardon? Right? And why not? Well, so can you and should you? No to both. So there's these things called the excluded categories of patentability, and they have to do with laws of nature, scientific principles and abstract theorems, methods of medical treatment, higher life forms, that's kind of an iffy ground here, discoveries and products of nature are really on iffy ground here. So there are certain things, mathematical principles, E equals MC squared, like all of the, basically everything in physics. Those are the tools of science, and you cannot, they're specifically excluded from patentability, because obviously it would stymie research efforts everywhere if you start patenting these things. So we'll talk about some cases that affect biotech specifically and really hard. So I'll give you a few of the cases, the history of the cases and how we got to this mess. So Harvard College and Canada, this is called the Harvard mouse case. Anybody heard of it? So Harvard College, Harvard in the US, created this transgenic mouse. They put oncogenes in it and created the oncomouse as a model. And they wanted a patent for it in Canada. They also sought a patent in the US and Europe and Japan and everywhere else. And the patent application said that they want to protect the process by which they generated the transgenic mouse and extended that to non-human mammals and the transgenic mouse itself. So the Supreme Court of Canada said what? Yes, go ahead and patent that, or no? Should you have a patent on a transgenic mouse? The US said yes, Japan said yes, Europe said yes. We usually follow the US, so therefore, did we say yes or not? Yes, no. No. Close, 5-4 split. And the majority said that higher life forms are not a manufacture or composition of matter. The minority said, well, an engineered oncomouse is an extraordinary scientific achievement and an inventive composition of matter, because they inserted something into this thing that wasn't there originally, and it was artificially inserted. Yes?
What is this 5-4 split?
So there are 9 judges that sit on the Supreme Court.
So ultimately, the law is determined by what the 9 judges
Yes.
consider the object to be.
Right.
So it's completely subjective.
And most of them have no scientific training.
Makes perfect sense.
Yes. So this isn't as bad as what comes after. So they said no. They said no. Then Monsanto in Canada, or Monsanto and Schmeisser. So farmer Schmeisser had land, I think it was in Saskatchewan, adjoining a field of another farmer who was using these genetically modified canola seeds that were Roundup Ready resistant, Roundup Ready, the weed killer. So those seeds were modified genetically to make them resistant to Roundup Ready. So they're called Roundup Ready canola seeds. And he said in the case that these seeds just happened to have blown onto his field. And he realized that, hey, these are resistant to the herbicides I put on my field, so let's recover the seeds for next season. So he did and replanted them, and somehow Monsanto found out about this, and obviously they were not pleased about it, and sued him for patent infringement. Schmeisser, so Monsanto had a patent on the genetically modified seed. Okay, Schmeisser said, I'm not infringing your patent because because he made profits from selling. So they said recovery of profits, and he said back, well, I didn't sell the seeds. Your patent is on seeds. I didn't sell the seeds. Therefore, I made no profit off your seeds. I stole the plant. And by the way, your patent doesn't protect the plant. It only protects the seed. So see you later. Well, didn't quite fly, because remember what they said in Harvard Mouse, higher life forms are not patentable, and you can get the thing on the patent on a process of making it, but not the animal itself. Here they had a patent on the seed, and the wise people at the Supreme Court in a 5-4 decision said that, well, what else would you expect to happen with the seed but to create a plant out of it? And therefore it extends to plants, and therefore now we have patentable higher life forms in Canada. See how this works? And this is 2004 and 2002. 2 years really wised them up. So that's Canada. And now we move into SCOTUS, the Supreme Court of the United States. And there's this decision that's cited a lot called Diamond and Chakravarti. And this was a bacterium that was genetically engineered with a couple of plasmids to break down crude oil. Boon for the oil people and everybody else who needed to get rid of oil. And so they claimed the process of making this bacterium and the bacterium itself, so the bacterium that had the plasmids in it. And the patent office said that living organisms are not patentable. So they argued with the patent office. And the court finally decided that it actually is patentable because it's not a product of nature. That bacterium that was originally used and initiated and the bacterium that's the product are not the same thing. And one is available in nature as is, and the other one isn't because it was engineered. So therefore, you get a patent on the bacterium. Now, jump to 2012, and we have the lovely case of Mayo and Prometheus. Unanimous decision. So the US has a 9-judge board too, or 9 justices. My old law professor in torts used to call them the Supremes. Somebody actually wrote that on an exam. He was not pleased. So unanimous decision by the Supremes here, 9-0. The invention was a method to optimize therapeutic efficacy of treatment with thiopurine drugs in people with autoimmune disease. So they basically had thiopurine. They measured the metabolite of thiopurine in the blood and patented that a certain range would indicate efficacy versus non-efficacy and the potential for sequelae that were not too good. So please give me a patent on that. So they got a patent, but they ended up being sued. And the court says that, no, this is not patentable because the steps involve natural laws and routine activities in the field. They didn't actually invent anything, according to the Supreme Court. All they did was basically play around with a bunch of ranges and identify this particular range. And now they want a patent on it, which means that nobody else really can use the same process of narrowing this down without paying some hefty licensing fees to them. So Supreme Court said, no way, you're not getting a patent. How do you feel about it? Should there be a patent allowed on something like this? I can tell you the biotech industry is royally ticked off. So that was 2012. Then 1 year later, it was a nice 5-year stretch of crazy decisions. The Association of Molecular Pathology and Myriad Genetics. This was a big case. It involves the BRCA1 and BRCA2 genes. And Myriad discovered the specific location of the sequence for both of these. And obviously mutations in these genes are indicative of breast and ovarian cancer. So people were using these tests developed in-house at various hospitals in the US and in Canada. And these guys went and patented it, and then they got sued for really bad practices not related to this, but that's a whole presentation in and of itself. We'll go into this a bit more deeply than the others because it's such a convoluted decision. So the questions before the court was, does Section 101, which is the patentability issue, whether that allows patents on human genes. So specifically, the question was, are naturally occurring segments of DNA isolated from the rest of the human genome patentable? Because they argued that, well, I'm not patenting the whole human. All I'm doing is extracting this, and I want a patent on this, please. And they said, well, you're breaking chemical bonds. It's not the same thing. Argued back and forth. And the second part is synthetic DNA, so cDNA, patentable despite containing the same protein coding info found in a natural piece of DNA, although it omits the coding regions or non-coding regions. Again, 9-0 decision. This one really ticked off the biotech industry. And here's why. This is from the judgment. Myriad did not create or alter any of the genetic information encoded in the genes. Just because you found it and just because you put a lot of work and money into this does not qualify you for a patent, because you didn't invent anything. You just did a lot of exploration. The Myriad's principal contribution was uncovering the location. The question is whether this renders the genes patentable just because you found where they are. And then they bring up the decision of Chakravarti with the bacterium in support of the fact that to distinguish this case from that case and say, look, these people got it because they actually made something new. What started off and what ended up at the other end is not the same thing. And they kept telling them that they didn't actually create anything. I'm sure that went well. So it says groundbreaking, innovative, or even brilliant discovery does not by itself satisfy the Section 101 inquiry. So it's not enough. And again, that it's just an iterative process. They use the tools of trade known to everybody on the planet at the time about how to go about this. And severing of chemical bonds didn't really matter. But had they actually created an innovative method of manipulating the genes while searching for them, that could have possibly gotten them a method patent. Missed the boat on that. Imagine what the IP person that actually drafted this was feeling when they read that in the decision. So they held that naturally occurring genes and the information they encode are not patent eligible simply because they have been isolated from the surrounding genetic material. Not good enough. But if you create a new product in the lab, so similar to Chakravarti, then it's not classified as a product of nature. So cDNA, by their definition, is intron-free. It doesn't occur naturally that way. But if you happen to find a stretch of DNA that is, so cDNA is patent eligible under 101, except if you happen to find a stretch of DNA that naturally doesn't have any introns in it, then that's not patentable, because that would reflect, that piece of cDNA would mirror what's naturally available, and therefore, good luck, but you get nothing. So, make sense?
Let's say you invent something as a cDNA, you haven't discovered anything where you invent like a code, and then later on some other researcher finds out that it is existing in nature. Would your patent now be invalidated, or what?
Based on this, what do you think?
Sure, right.
Yeah. So this is, again, people were very upset because justices, 9 of them, without any depth of understanding of biology and genetics, made this decision. Now, on some level, there shouldn't be patents on genes. That's just counterproductive. You're monopolizing things. And actually, on this topic, the Eastern Hospital of Ontario, the Kids Hospital of Eastern Ontario in Ottawa, had gone up against this and challenged whether genes are patentable in Canada. Because although Myriad's patents everywhere else in the world were struck down, they still stand in Canada. So they took it upon themselves to challenge whether we allow genes to be patented. And last year, they went to the court system, but they ended up settling. So the company that owns 5 patents on the long QT syndrome had come to an agreement with the hospital, and they are going to offer, allow the hospital to use this IP free of charge, no license. And so that's the settlement, and it's supposed to be now a paradigm going forward for every other hospital, public institution, not private, to use these kinds of technologies without paying. So not exactly an end solution to whether they're patentable or not, but as far as genetics and technology is concerned for human health, they arrived at that conclusion. So the last one is Alice Corp and CLS Bank. This is a it's a software patent. And it's important because what they actually wanted to get a patent for was this trading system where the risk of non-payment for a buyer and seller were mitigated by a third party. So there's basically insurance. And you can do this on paper, and the court was none too pleased for them to be asking for a patent on it, and said that, look, just because you can do X on paper and now you want the patent for it done on the computer, it's not enough. And this sent all the software patents and the business methods patents into a tailspin, and the numbers that are actually coming through are dismally low compared to what they used to be. And the court basically says that the essence is that merely requiring generic computer implementation fails to transform that abstract idea into a patent-eligible invention. So there's got to be something more. The court didn't decide or define what that is, so they'll know it when they see it.
So that means that, like, pseudocode, like you can't patent pseudocode, let's say?
It has to be packaged in a way that a court looking at it can see that it's not just straight up putting things on a computer. So you package it as part of a product or part of a system, or the patent bar has come up with all sorts of workarounds for this because it's created a real problem in just patenting software generally. And the federal courts are trying to sort this out, but each jurisdiction has their own version of what it should say. So it's created a lot of problems. So if you're going down the road of patenting anything involving software, heads up that it's becoming really difficult lately.
The code itself is still covered by copy.
Yeah. And then the last one is this latest case where they were trying to undo the mess from the previous cases. Didn't quite go anywhere. So Ariosa and Sequinum, it's a blood test for a cell-free fetal DNA that was using fragments of paternal sequences to distinguish from maternal sequences to test for genetic abnormalities for fetuses in the mother's blood. This was inventive. Nobody had thought about the fact that you can use paternal pieces, amplify those to assess or to predict the likelihood of there being a fetal abnormality. And they claimed the method to identify inherited material. The court had to say no because they were bound by their previous decision in Mayo that said that you can't do this because you're basically, and Myriad, because you're basically using the tools, the common tools of the trade to arrive at this conclusion. So even though that inventive step was there, they're bound by the previous decisions, and this is a lower court, and they cannot issue a patent for it. They tried to escalate this to the Supreme Court to give them an opportunity to fix the mess they created in the eyes of the patent bar. On the previous cases, the patent or the Supreme Court refused, so it stands as law. So grudgingly, the federal courts have had to not allow this to go forward, so the patent was invalidated. Okay.
Sorry, that's a example. So with how penicillin got turned.
Pardon? How?
Penicillin.
Penicillin.
Right. So originally, I mean, it was a mold on a cantaloupe.
Accidentally left out.
That's in nature. But then another doctor, but he hit it with X-rays and mutated it, got the yield 1,000 times. Now, I mean, hypothetically, if that were to happen now, would that mold now become that?
Well, what do you think on the basis of these things? Is what we start with the same as what we end up with? If you're zapping it and creating mutations, you can argue that it isn't. So if you're in the US, you cite Chakravarti and say, well, but this is not A is not the same as B. This is not A prime, it's B. So it's nobody really knows what goes on anymore. So when you try to patent anything in these fields, it's a roller coaster ride. It normally is patenting anything because you never know if somebody will come back after you and sue you for infringement, or somebody infringes you, or there's a patent troll that decides that you're, you know, red meat for them to make money. There's now such thing as patent insurance that costs thousands of dollars, basically the same thing as a ransom from a troll, so take your pick. You get fleeced down at some point or another. Not so much here, but in the US it's been brutal. They've tried to adapt the laws and change some things. That's another whole lecture on it in and of itself, but it's tough. So you don't know going in what happens. So we'll talk about strategy next, but it's a rough ride.
Isn't the embodiment part of describing a patent something that should be taken into consideration when evaluating whether something should be patented or not? So, for example, like if you're shooting, this is a previous example, if you're shooting X-ray at a bacteria, perhaps it mutates to something completely different every time, then you're not generating something consistent every time.
It's not reproducible.
Yeah, so it's not reproducible.
That would be the counter argument, right? Because it has to be reproducible. The whole point of patenting is to get the same result every time you practice the invention. And if that doesn't happen, the argument on the other side would be, well, but that's not this, it's just a chance. And we are not in the business of patenting or giving people patents on chance games.
If certain marketplaces don't allow for previous disclosure of patents, so if I patent something in Canada and go and try and patent it in like Japan, is that considered previous disclosure? Is that what like the patent?
You can't, it's worldwide. So if you patent something here and then you try to patent something else, the same thing elsewhere, outside of your 12-month window, or as we'll talk about some other strategies, that is prior art, even though it's your own. So you have to be careful.
The 12-month window is international.
The 12-month window, the grace period only applies to Canada and the US. Right? Everybody else says, no, you messed up, tough. So we'll talk about strategy next. Any questions on subject matter?
And then if you talk about like, so I believe you said that code is there for copyright instead of patents.
So we'll talk about trade secrets, and remind me to touch on code because I put it in there. So we'll talk about strategy here. True or false? Patent strategy precedes business strategy. Who says yes? Anybody else? It's the other way around. Most people think of it as this. This is, keep in mind, this is in the context of actually starting a business, okay? And most people will take it, well, business strategy comes later. We'll come up with a business after we patent the invention. And that sometimes leads to really problematic ends. So the idea is you need to practice, or you need to patent strategically in such a manner that it advances the aims of your business plan and your business strategy. And you need to know who your competitors are and what the market is, and do all sorts of analyses that we'll talk about before you figure out where you're going. Because imagine you just patent blindly without really knowing what's out there, and then you find out that you have a nice patent that is useless and you just spent $30K getting it. So we'll unpack that in a bit. Patent systems. First to file versus first to invent. Do you know what that means? And who has what? No. So the US up to 2013, I think it was, the American Invents Act, they were in the first to invent category. They were the lone wolf worldwide in this. That basically said that if two people invented the same thing, it's not the person who filed first, it's the person who invented first. And the CRISPR-Cas mess with the patents is one of the remnants of that system, who invented that IP first. It now changed to first to file, So whoever gets to the patent office first, and obviously whoever has the deeper pockets to get to the patent office first, gets, you know, the prize of the patent. So we have that, and so does everybody else in the world, and so does the US now. But it used to be, the old system used to be first to invent. So you had to basically mail things to yourself and not open the invention, and you sign across the back of the envelope, and it's dated by the post office with a stamp, and this is, you know, old school stuff. We don't do that anymore. So now, when you're thinking about patenting, where do you patent? And so there are a variety of places like national offices, regional offices, and when you think about where to patent, you don't not only think about the costs, but as we talked about, subject matter, because something can be patentable in one jurisdiction and not the other. But if something is patentable in Timbuktu and your business strategy does not involve Timbuktu, why would you go there? Because it's expensive to patent in jurisdictions, and maintenance costs and all these add up. There's a slide on costs, so you have an idea of what that means. So this is what I talked about, the Paris Convention. So say you patent, let's say you patent in Canada, and you file your application here, and then within 12 months, you have to decide where else in the world you're going to patent under the Paris Convention. And if you don't do it by then you can't. You're precluded from patenting it there. And then there's this. The PCT is the Patent Cooperation Treaty. And what this intends to do is allow you to patent in multiple jurisdictions, but unlike the Paris Convention, where you only have 12 months to make up your mind, you have 36. 30 months. Till the end. This is on the WIPO website. Everybody who presents will pull this thing up because it's comprehensive. It's busy, but it's comprehensive. So the idea, I'm not going to spend too much time on it, but the idea of the PCT is to say, I'm going to file one application in one of these offices, an international office or international application in one of these receiving offices. And then from there, it goes to the system of prosecution. It's reviewed. The patent office reviews it in the receiving office. We have one here. And then it makes its way down the line. And eventually it's allowed. Let's be positive and assume it's allowed. And then all of the signatories to the Patent Cooperation Treaty are there and available for you. You make a call as to which one you want to go, which jurisdiction you want to go into. At that point, at the 30-month mark. So the national phase entry, you decide. It could be 2, it could be 1, it could be 15, but you only filed one application. Now, you'll get individual patents issued in those jurisdictions. There's no such thing as an international patent, which people confuse the PCT with. There's no such thing. You get one in each country. So you have to pay the fees associated with that jurisdiction for the patents. But at least this gives you a bit of breathing room to sort out what it is that you might want to do and sort out your business strategy, because most people will start off with patents and then think about the business strategy. So this gives you a bit of space to make up your mind and sort out your financials and what you can and can't afford. Okay? So questions on this? If you actually have to walk through this, the patent agents will have to walk you through it. So just to give you an idea of what it costs to put a patent out there, let's just say I want 2 jurisdictions and I'm going to do it through the PCT. The filing fee, just the filing fee for the PCT is $5,000. This is 2 years old, so it's probably over $5,000. Each national phase entry, so I'm picking US and Canada, so it's going to be the $5,000 plus the 2 plus the 1,100. And then depending on how many claims and what kind of claims you have, you get dinged on that too. So 210 for each independent claim. We'll talk about what those are after the 3rd claim. So you get 3 bonus, and after that they charge you. And then 390 for claims with multiple dependencies, which we'll talk about too. So when the patent issues, you have to pay again. And then to keep it alive for the duration of the 20 years, you have to pay again. And in the US, that amounts to $7,000, and in Canada, almost $9,000. And then you have, this is just fees. The patent agent hasn't done anything yet with your patent. The prosecution hasn't been paid for. So I've never seen one go for 2,000, but let's just assume it's very, very straightforward and it's only 2,000. It goes way past that. And patent agents usually make $350 an hour plus, depending on where you go and which firm does it. You can be looking at 800 plus an hour for, you know, a large patent firm or one of the 8 sisters to do it for you. So it adds up. So you're looking at just two jurisdictions, a minimum of 35K, and that's conservative. So this is why your business strategy has to precede the patent strategy, because if you don't do this right, you'll be throwing this money down the tubes and it's not recoverable. So you need to be very strategic about how this is unfolded. There is the PCT website, or the WIPO website actually has all of that. I have not committed them to memory. I'm not a patent agent because I have enough to do. This is a career in and of itself. Okay, so when you file something, have you heard of a thing called a provisional patent? Okay, so it's a very, is and was a very common strategy in the US for a reason when it was first invented. Now, not so much, but if it's used by basically all the academic institutions as an emergency, but then they now use it, they just use it. Say you have to go and present at an international conference and you haven't gotten around to declare or disclosing your invention to the patent office of the hospital, and then you realize that, hey, I heard somewhere that this is going to constitute public disclosure, and if I want to patent this and I don't protect it, I might be in trouble. So you run to the patent office a day before your flight takes off and say, I'm going to present this, and it's not just a poster, I'm presenting, help. So what they can do is literally throw your paper in as a filing, because provisionals don't require claims, which is where a lot of the time is taken up. So they just put that in there to secure your priority date. So anything before that date can count against you as prior art, but anything after that doesn't. Okay, so it's a stakeholder, this provisional application. Now, if you're more organized and you don't want to pay twice, first for the patent, for the provisional, and then for the actual application, then you organize yourself enough to file a full application and then go from there. But it happens in emergency situations, and for other strategic reasons, people will use the provisionals kind of to just, like I said, put a stake in the ground so that prior art doesn't count against you after that.
If you have a grace period of 12 months in the US and Canada, and the provisional application has a 12-month term, what is the benefit of paying twice, I guess, for that provisional?
Well, I had this conversation with my husband yesterday. So it depends on what you want to do. So it might be that financially you can only afford so much, and then you put your provisional in place, and then you deal with it in 12 months. And in his case, there's a paper that's coming out in 2 weeks. So what are we going to do? And does it make sense to do a provisional? Can I just make a full? Well, if you can get the full application in, just do that. It saves you money in the long term. It costs more and it takes more time, which 2 weeks might not be enough. So then you're getting into the grace period. And the grace period is from the date of disclosure. So if the clock ticks from different times. So the logistics on that have to be sorted out literally on paper to make sure that you don't inadvertently shoot yourself in the foot. But as a general rule, if your invention's all there, just file properly. Otherwise, patent agents make money off of you. So there's that on provisionals, questions on provisionals. And then just briefly, just to bring this up so you're aware that these things exist, there's such a thing as a continuation and a continuation in part in the US. We don't have that here. It basically allows you to make revisions to your existing applications. There's a requirement that each invention or each application can only have one invention. So if there's more than one, then the patent office will ask you to split it so you get divisionals. And then you have your full patent applications, and you can file it in national, regional, or PCT. Keep in mind that they're published 18 months after original filing. So if you had a provisional application and then you filed a year after that, so within the 12 months, there's only 6 months left on the clock before it gets published. And when you do your due diligence on patents, you have an 18-month black window where you don't know what's coming down the pipe. So when you're doing your freedom to operate analysis, which is what we're going to touch on soon, keep that in mind because you're working blind.
If you have to split your patent using initial because you have two mentions, do they both continue on the same stage, or like does it kind of like take you back to square when you like refile?
Oh, they'll make you pay the fees. They won't miss a chance on that. So because the prosecution gets you to that point and then they realize, okay, well, there's 2 kids in this bucket, so we're going to split each, and then each will take their own course. So fees going forward, I don't think they take it retroactively, but at least going forward, they'll be charging you twice, and then your patent agent will be charging you twice because it's 2. Okay, so trade secrets. So given what has gone down with the Supreme Court, both here in the U.S., especially in biotech, there's now a tendency to start looking more closely at protecting stuff through trade secrets instead of disclosing it. So now the trick with trade secrets is, we'll skip this. It has to be kept secret, and it has to have. You can't just keep anything you want a trade secret. So, for example, code. Code is protected by copyright, but copyright's pretty thin as a protection. So that's not enough. So for example, the Google algorithm is a trade secret. A lot of the algorithms are trade secrets. They're not going to publish it. They don't want to patent it because by patenting, you actually have to disclose what it is that you're doing. And you don't want that in this kind of situation. So then you keep it as a trade secret. So this is more where the world is heading, especially in software and tech. Biotech has its own problems, but even there, you might start thinking about keeping this a secret. The thing is, though, that if I'm keeping this as a trade secret and one of you decides to patent it, and you get a patent on it, and I'm still going, hey, I have a trade secret, tough for me, because the patent trumps the trade secret. So that's the trade-off. That's the risk you run by keeping things a trade secret. Make sense?
So if I made a recipe for something that was almost the same as the roulette and patent it, could I have cases like say that they can't make that anymore?
Well, then you go into, so the way people deal with, somebody actually has to look and compare. It's a trade secret, so the whole point is to keep it secret. So then there are these things called escrows. So somebody that designates, swears on their children and grandchildren that they're not going to divulge what it is, and then goes and looks and compares. You don't want to ever be in that situation. It's not pretty, and it endangers your trade secret. And if you go against Coca-Cola, they've done this more than once. So, you know, pick on somebody your own size because you don't want to go against them. But that's the risk.
So can you keep modifying the trade secret?
As long as you keep it secret. So it's usually locked away, limited, or a few numbers of people know what it is. They're kept in possibly multiple locations, usually locked up in some vault somewhere, in a bank or somewhere else. But they have to be qualified as a trade secret under the Trade Secrets Act. It has to have monetary value. Now, it's arguable what monetary value means to me versus to you, so it has to be commercial value. So you can argue that way. But it's an option or an alternative to patents in certain situations.
Yeah, Coca-Cola has to print the ingredients on the label. So what's the limitations of trade secret?
Well, just because I tell you that I have A, B, and C, it doesn't tell you how much of each, right? And I can say that it's fructose corn syrup, whatever they put in there, and great, it's a common ingredient. there might be a specific ingredient that's left off the list. So how that is enforced by the food regulatory people is another matter. But I can disclose everything that's in there in a recipe, in a laundry list, but you don't have the recipe of putting it together, right? So that's the trade secrets are okay, but they're tricky, and you have to be really careful to get it right and make sure it's secret, because once that goes, it's no longer a secret and it's done. Okay. It is 6 o'clock, no, 5:30. I just want to know how much time, and we go till 8.
Yep.
Okay. I lost track of time. Okay. We talked about this. Keep it confidential. Confidentiality agreements. Those, by the way, are called NDAs, non-disclosure agreements. They're usually not worth the paper they're written on, but everybody has them because they're hard to enforce. So it's a deterrent for people, but somebody who really wants to stick it to you, they can. And if you're going, you know, David and Goliath situation, well, good for you for being David, but it's not going to work because they're going to spend you out of, bury you in litigation costs, and you'll get nowhere. So just keep that in mind. Everybody signs them, they're there, but enforcing them is a different matter. Okay. So we talked about freedom to operate. So we're going to go do some of that in more detail of what it means. I thought you guys would have computers. So the exercise was meant to be getting you to actually go do some of this, but we'll just focus on the patent and walk you through the patent more slowly than I plan to do. So this is your market clearance search, because ideally, as we talked about, you do your business searches first, your competitors search first, then you go look into patents, because that gives you an opportunity to do a few things. Make sure that you don't infringe anybody else's rights. How would you know what patents to look for if you don't know what competitors you have? Doing a patent search is a royal pain to do by hand. There are services that do that for you at thousands of dollars for a search. So there are ways that you can parse through a freedom to operate by hand and sort of sort out the major players. But understanding where the market, what the market is for your invention, first of all, and who the major players in that market is, and what their patent portfolios look like. And keep in mind that for 18 months continuously, you don't actually know what's going on with any of these individuals. It's a bit like fishing with a blindfold on, and you need to be cognizant of that. But so the framework for a freedom to operate is as a series of strategic steps in innovation management and risk assessment. So you do your analysis, you figure out where you stand, you can get an opinion, a legal opinion, which don't come cheap, and then you get to a freedom to operate analysis. And legal opinions in this field have to be qualified in such a way that ultimately doesn't tell you anything. As far as we know, based on the information you gave us, as far as the patent system or the tool that we use to search, whatever we had access to limits all of this. So nobody is going to sign off on an opinion of patentability and says, yes, you're free and clear. You get a laundry list of what can go wrong and what can be cited against you. So you never really know where you stand. The only time you know if your patent is valid is when? Just one instance. Like definitively know that your patent is fine.
When your patent's accepted.
Nope. When it's challenged and at what level court. Yeah. So imagine how many thousands, like millions of dollars that will take. So that's the only time you can sleep easily, and you only have a 20-year patent term. It takes about 4 to actually give it to you if it goes through. It's going to take a little while for somebody to come sue you or challenge or whatever. It's going to take another few years to actually get to the Supreme Court. So by the time you walk out of there successful with your patent, it expires in 2 weeks. So, you know, there's only so much you can do. And then everybody can use your patent once it's done. Okay, so no absolute guarantee, but it kind of allows you to navigate and avoid certain things. So if through your freedom to operate analysis you come across a patent that you never really thought that was out there, that basically says exactly what your patent application says, and you found it early enough, you can try to get a workaround this thing, and such a deviation of the workaround that you wouldn't need that license from the current patent owner for you to practice your invention. When I did one of the first patents with the company that was spun out of my lab way back in grad school, we needed a nozzle to make these microbeads, and it was owned by a Spanish company. And we thought, okay, well, we bought the nozzle, we made these things, they worked well, and then we needed to get a license. So we got on the phone, and the guy says, oh, well, sure, we're happy to license it for you. It's $2 million upfront, and then whatever there was for royalties, which didn't matter because we didn't have $2 million upfront anyway. So, you know, you kind of work around and figure out other ways to create these things. And in some instances, like a nozzle, it's not the end of the world, but it could be something on which your business or your product that you're trying to commercialize hinges. And if you haven't thought about this by doing a freedom to operate analysis, you'll be up a creek with a $2 million thing hanging over your head to practice an invention that may or may not be challenged further down the line. So it's not a situation that you want to put yourself in or your company. I told you 9 out of 10 companies fail. See, this is part of it. Now, why conduct it? We kind of covered all of this. Assess the other side's portfolio, detect 3P means third-party patents. They may hinder your invention or commercially exploring it. See where the field really is and plan accordingly. And it reduces this risk of launching something that you will never be able to sell, because as soon as you put it on the market, you'll be bombarded by left, right, and center of people trying to sue you for infringement. And redirect your R&D efforts to try and see if there's another way to do it and go down that road. And if there isn't, you make a very hard decision about whether you're going to take this risk or not. Because believe it or not, there's a strategy behind actually putting something out there that infringes on somebody else. What do you think it is? If I am a small entity and I want the attention of big pharma, but big pharma won't pay attention to me, and then I put something like this out, and it's close, it's an improvement on something they have, and it's a good improvement, and I want to try to put something out, so I put out a product that actually infringes on their patent, but uses my improvement. That will get their attention because they have armies of people who look at everything that comes out on a daily basis out of the patent office. Because like I said, you can't take a nap one day and see, miss what came out that day from the 18-month black box. And then they can say, oh, cease and desist, thank you very much. You need to stop or we'll sue you. At which point you can say, okay, well, let's enter into some discussions about either you cross-licensing your stuff to ours and vice versa. And we'll talk about licensing and how you do that. We do it in this jurisdiction, you doing it in that jurisdiction, and everybody's happy. Well, by the way, we're for sale. So why don't you acquire us for this patent and our expertise? So you can leverage that to really, bring your invention to the attention of bigger players in the market. So the process of searching for patents, you go through these databases. The USPTO has a database, CIPO has a database, the Canadians and the US patent offices. WIPO, the World Intellectual Property Office, has one. There are places, or things like Derwent and a whole bunch of others that do this for a living. There's always Google patents, but you have to do it by hand, and you have to be strategic about how you do it, because you can do it by keyword. You can do it by really knowing who the main players in the space are, either from an academic perspective, where you might have a lot of university-owned IP that's licensed elsewhere. But if you know who the major players are, they're the most prolific, you go look them up, see who licensed their IP, and then find out where that goes, or you do it by companies that you've uncovered from your market analysis, who your competitors might be. So there are a lot of different ways. You have to keep track of all of this stuff. So I've done it by hand, and it's not something I will jump at the chance to do again. It's doable. It's never thorough, because you can't possibly have a thorough job of anything. And there's the other problem of me calling an apple and the patent calling it a pear, but it's actually an apple. So we'll talk about those when we look at the patent. And then there's the costs and all of these things, and lapsed and dead patents or abandoned patents. People can't pay for 20 years of maintenance fees. So at some point or another, unless it's a big company, these things will lapse, and that IP will go into the public domain, and then you can go use it to your heart's content, because they can't do it in the jurisdiction in which it lapsed, because it's not public. Okay, so we'll talk about licensing in a little bit. So in Canada, there's an S versus a C in a noun versus a verb. So the Americans always get ticked off at me and correct my spelling because it's S and I put C, but difference of opinion. There's an assignment. Okay. When you talk about IP and patents specifically, you can assign it or you can license it. Okay. What do you think the difference is? Rent versus own. Okay. When you assign it, you just give it all away. The original owner basically sells it to you. You now have full rights. The owner has nothing left. In a license, the owner retains control rights, and you get to play with it for a certain amount of time in a certain area. So an assignment is irrevocable. That's what makes it stick. It's like a sale. And it's a permanent transfer, and it's recorded in the patent database, US and Canada and everywhere else. And a license gives you either exclusive or non-exclusive rights over this IP that you're licensing. But the licensor, the person who owns it, always retains rights over it. And there are some really fundamental definitions for a license that dictate how broad your playing field is with regard to the IP that you're licensing. And these are the key provisions, the major provisions on which licensing turns. So field of use, you're allowed to have, so you have an invention that does, it's a medical device, and it's for mind tech. So for tremors, device for tremors. And it's you're licensing it from, let's say, Sunnybrook. And Sunnybrook says, okay, you can have it, so you're licensing it for diagnostic use in humans or no other use. Say tremors are not only prevalent in humans, but in primates, and you're interested in that as well. Well, the field of use tells you that you're only allowed to use it in humans and nothing else. You have to be very clear and very specific about what this says. Because if you put it as a field of use of diagnostic use in humans, but not therapeutic use, you're introducing therapeutics into something that shouldn't be there. So to make it clear, it has to be very tight and specific. You're licensing the technology. So what the technology means is important, because keep in mind, the patent in and of itself does not constitute the whole technology. I can give you a patent and you try to do what the patent says, but without the know-how, the protocols and all of the rest of the things that don't go into the patent, you may or may not be able to arrive at a successful end. So when you're patenting, you get the IP, the patent or the patent application, along with the know-how, the bundle of information that comes with actually putting this thing into practice. And if you ever see a license agreement that licenses technology without the know-how, alarm bells should be going off. And then you get it in a specific territory, like we talked about. So if Sunnybrook wants to license this technology to you, and they only give it to you in the US and Canada, they can turn around and give it to somebody else in Europe and somebody else in Australia. So you can really parse this multiple ways. So you have to be very careful about how these things are defined. And to do that, you need to understand what the kinds of licenses are out, what kind of licenses are out there. So everybody seems to know about exclusive licenses. That's the standard that every licensee wants, because that excludes other people or prohibits the licensor, the owner, from licensing the same thing to other people. But they are allowed to license it in a different field of use, in a different territory, and it's, again, comes back to the definition of what that is. And you have to be very careful. The licensor, the person owning it, still has the rights of control. They can't practice it in an exclusive license. The licensor themselves can't practice it. That's not the case in a sole license. These are rare. It's like an exclusive license, but the licensor actually has the right to compete with you as the licensee. One of these actually came my way and it was bizarre, but these are very rare. So if you see anything like that as a sole license, make sure that they understand what a sole license is. In my case, they didn't know the difference, and that was a problem because my client clearly did not want to compete with this particular entity. And then the rest of it, or the third option, is a non-exclusive. So every one of you is a party to a non-exclusive license. Multiple ones, actually. Any ideas which? You're in the software space. Every time you download an app, every time you use Windows or OS or whatever you use, all of that is a non-exclusive license between you and whoever's on the other end. So you're a party to lots and lots of non-exclusive licenses. So the difference with these is that the licensor can license them to multiple entities for the same period, for the same field of use, for the same territory, so they go compete. And they're non-exclusive, so that means that obviously there are more people on the other end of it, and they're cheaper because the licensor, for the licensee, the licensor makes more money because you're licensing the same thing 50 times over, versus an exclusive license where you have to put all your eggs in one basket into this one company that may or may not exist tomorrow, and you have to be able to hedge your bets on that. So the fees and the royalties and everything are much higher, obviously, in an exclusive license because of that exclusivity. It comes at a premium versus a non-exclusive where if one happens to fold, there are 15 others from whom you're going to be collecting your fees. So keep in mind that there are 3 different kinds of these things. So when you're granted the license, this is where everything gets pulled together. So this is actual language from a license. The licensor hereby grants to the licensee. It's asked to say hereby because it means it's a point in time right now, not will. That doesn't give you anything. It's just a promise. Oh yeah, I'll give it to you. Good luck when you want it, but you don't have it as of this moment. So it has to actually say hereby grants to the licensee an exclusive license in this case of the technology. Defined terms are always capitalized. Effective throughout the territory, which could be worldwide or it could be just Canada or the US or whatever else, and within the field of use. So you can do any of the things listed there within these parameters. Okay, it's very important to make sure that these things are defined and you've thought about what your business strategy is again, in order to make sure that your license actually accounts for everything that you want to do. Because otherwise you come back and say, oh, by the way, but I'd like to expand the field of use. And they can say to you, or the field of use or the territory, and they can say to you, sure, but that's going to be extra fees and extra royalties and all of that. So better get it right from the beginning and then move from there. The only thing I want to show you here is, forget about the ownership, inventorship. This thing, the notion of chain of title. Every time you have an invention that you develop, let's say it's on your work at U of T or the hospitals, anywhere else, you're bound by your employment agreement to assign it to the institution. When this invention actually happens and you file it with the patent office, there's a disclosure there, or a declaration, I should say, there, that you're the inventor. And that has to be executed. And you have to execute an assignment from yourself as the inventor to the institution, and that has to be documented. Because if somebody were to license or finance you in the due diligence process that that investors go through, they look for chain of title. Because if the chain of title isn't clear, so that my rights are passed to the institution and the institution actually has the right to go license it to somebody else, if there's any gaps from any of the people listed on that invention, that creates problems, and it's an opening for being sued, or the financing people to come poke holes at you, and you really, really, really need to be careful about that. Because you don't want somebody to realize that, well, you didn't collect the assignment from one of the inventors, and now that inventor is free and clear to do whatever they wish with this IP that you're licensing or trying to license or think you licensed somewhere else. And that would be a breach of a covenant or a warranty, for which you have to declare when you sign on the dotted line of a license that all of these things are clean and there's nothing floating out there in space that can come back. So it can get companies into a lot of trouble if that's not true. And it opens you up for a lawsuit where you don't need one. Okay, and this is also important to know, reserved rights when you're dealing with an academic institution, they will always have something similar to this that basically says that, yes, we're giving you the rights to license this IP, but we also retain the right to use it for academic and non-commercial purposes, because it's in the interest of it's in the interest of science and academics for it to be there. And as you see, it's royalty free. They're not going to pay you anything for it. Non-exclusive, perpetual, irrevocable. It's buttoned up where they can do whatever they want with it as long as it's not commercial use. And if you were to develop any products based on this IP that you're licensing, and the university or the institution decides that it's a product that they would like to purchase, you have to promise them that you're selling it to them at the lowest price, because after all, you wouldn't be selling anything without them. So that's kind of the full circle on the IP. And what will it cost you to do a license? Well, as I mentioned to you, there may or may not be a licensing fee, and that can go anywhere from 10K to a few million, depending on who you're trying to bargain with. There's royalty payments associated with it. Now, there are royalty payments based on patented technology and non-patented technology, and these things are negotiated heavily. There's a broad range depending on what you're doing. Then there are sub-licensing fees, because a license can come with or without sub-licensing rights, meaning you can go and be the licensor to somebody else, and you collect fees just like the licensor is collecting fees from you. But the original licensor will want usually about a 15% cut of everything you make, because you're trying to monetize and make money. So there's sub-licensing royalty payments, and in order to make sure that you don't sit on the invention, because academic institutions that license don't want you to just sit on the invention, they could turn around and license it to somebody else, they will ask for something called an annual minimum payment. So whether you're doing anything with it, commercializing or not, you're going to have to give them 10K, 15K, whatever it is, on a yearly basis. So this is supposed to be incentive for you to get moving and keep going to actually commercialize this. Otherwise, you're burning through cash that you usually don't have. And then you negotiate when that actually kicks in. And then there are payments on certain milestones. So depending on what it is that you're inventing or licensing rather, if your sales, for example, reach 1 million, then you have to give a milestone payment of X. Then as it increases, those payments increase as well. When the patent issues, they may charge you a fee then, even though you're paying for all the IP prosecution during this whole time. If it's got any regulatory components to it, then there are milestone payments associated with issuance or filing or whatever. So as you can see, it adds up to a lot of money to license anything. And you have to be really careful about structuring it in such a way that you go with your eyes open into these things, because you actually have to do the math of what this actually ends up costing you. And it's spread over time, but if there is an upfront licensing fee and an annual minimum payment, you might not be able to afford it. And then if you breach your obligations and you can't pay, they can call the IP back. So you have to be very aware of what these terms are and what to do with them. Okay, that's where the exercise starts. So we're going to stop. Any questions on licensing? I know this is a whirlwind of information. I usually teach this in 12 hours, not 2.5. But it gives you a really, really broad overview of the main components that you have to kind of have on your radar, and at least know that somebody at some point told you that this is important, and you can go look it up later when it applies. Okay, so break time.
Yeah, if you guys want to take 5 minutes to ask Gabriella any questions. I think you really deserve a very well-deserved break. We're going to take it, but yeah, just want to open for questions before we close the webcast, so all my viewers can hear your questions if you have any.
No.
Okay, let's go over the break.